Well, good afternoon, everyone, and welcome to this first CAFII webinar of 2023 with two leading Canadian experts on privacy, Dallas Ewen of Canada Life and David Elder of Stikeman Elliott. My name is Keith Martin, and I am the Co-Executive Director of the Canadian Association of Financial Institutions in Insurance, or CAFII. On behalf of myself and my Co-Executive Director colleague, Brendan Wicks, and the CAFII Board of Directors, thank you for joining our webinar today. Now, CAFII is a not-for-profit association dedicated to the development of an open and flexible insurance marketplace. Our 14 members include the insurance arms of Canada's major banks and credit unions, along with their insurer business partners which underwrite credit protection insurance and travel insurance. This is the first of three webinars which we will be holding in the first half of 2023 with key opinion leaders, regulators, and policymakers in the insurance space. Today's topic that we will be discussing is emerging issues and trends in domestic and international privacy legislation, regulations, and enforcement from an insurance industry lens. Now, I want to mention that today's webinar will be recorded and posted on our CAFII website in the near future. So if you have some colleagues who can't attend live but would like to see the webinar, just direct them to the events section of our website and they can see it there. As well, if you have any questions today that you would like to pose to our panelists during the session at any time, please send them to me as the host using the Q&A function of Zoom, and I will pose the questions on your behalf. Unless you specifically request in your question to be identified as its source, I will pose all questions to our panelists on an anonymous basis. And just before we get underway, I want to extend a special welcome to a number of VIP guest attendees. In addition to many representatives from our 14 CAFII member companies and our associates, we have attendees today from allied industry associations such as the Canadian Life and Health Insurance Association, or CIA, the Canadian Life and Health Insurance Association, or CLHIA, the Travel Health Insurance Association, or THIA, and the Canadian Bankers Association, or CBA, and from insurance and financial service regulators and policymakers from across Canada, including the Canadian Insurance Services Regulatory Organizations, or CISRO, the Insurance Councils of Saskatchewan, or ICS, the Alberta Insurance Council, or AIC, the Government of Alberta, the British Columbia Ministry of Finance, and the British Columbia Financial Services Authority, or BCFSA. Welcome to you all. Well, let's jump right in. I'm going to start my first question first with David Elder, and then I'll ask Dallas Ewen to jump in. David, at a high level, how effective are the existing privacy regimes in Canada and their commissioners, both provincial and federally? And I'm thinking of such issues as consent, fostering digital innovation, mitigating identity theft and fraud, breach notification, and just generally monitoring and enforcement. David?
I actually think, and certainly from a business perspective, I think that our existing privacy laws have been quite effective and have served us fairly well. You know, the Canadian privacy laws, particularly in the common law provinces and federally, are principles based, meaning that they have built-in flexibility and adaptability. And as a result, our privacy commissioners, I think, have been able to deal with a wide range of new technologies and data uses and issues, you know, things like biometrics, facial recognition, tracking by mobile apps. All of these things, you know, the privacy commissioners were capable of making rulings on and issuing guidance. I think there's a misconception, you know, in some parts that monetary penalties are required to ensure compliance. In my view, there's already significant incentives for companies to comply, given reputational damage and civil liability. I don't think there's any legitimate company that's going to intentionally flaunt privacy rules, but there can be mistakes. there certainly can be some uncertainty about interpretation of the law. And one thing that a lot of people don't appreciate is that currently the privacy laws, with the exception of Quebec, are largely based on an ombuds model, so that the commissioners don't have direct powers they don't issue decisions, they can't make things happen, they just issue findings and make recommendations, can't impose penalties, that sort of thing. So as a result, there's nothing to appeal from. And so we sometimes get situations where a company doesn't agree with a commissioner's ruling, and they have no way of challenging that because it's not appealable. You can't take it to a court. So they really are just faced with the either just swallowing it and going along with whatever the privacy commissioner says, whether they think it's right or not, or saying, no, we're not going to do that. And certainly when they say the latter, it's when it gets privacy commissioners' blood boiling and pounding the table for monetary penalties. Anyway, enough about that.
So generally fairly positive view of the regime, David.
I think so. Yes, I think we've done very well in Canada. I think we can be very proud of our privacy laws.
Dallas, you're approaching this from the business perspective at Canada Life. What are your thoughts?
Well, I would share David's appraisal of the current state of things in Canada. I think that privacy regulation by the commissioners has been generally positive. It encourages industry to act appropriately, of course. We've got, the privacy commissioners express their sentiments about what's acceptable and not acceptable. Sometimes we agree, sometimes we disagree. But we always take those things into consideration when we're formulating plans and doing privacy impact assessments on various activities we're up to. We'll be talking about developments federally later. I've got a whole section on Bill C-27 I'm going to talk about, but I wanted to just, give a sneak preview of that. When David was talking about the lack of opportunity for companies to disagree in a more formal way with commissioner findings. That's one thing that's addressed in C-27 with the establishment of this data tribunal, and we'll talk about that in a little bit. I know that just in closing on this topic, there are privacy enthusiasts and critics that have criticized our regime in Canada for, among other things, its lack of ability for commissioners to make binding orders or to impose administrative monetary penalties. Those things are coming, not quickly enough for some and not intensely enough for some. But I think Canada in general has done a good job of balancing the interest of business with the interests of individuals with respect to their personal information. And we'll be talking more about Bill C-60 or Bill 64 in Quebec and C-27 federally with what those developments are going to be.
Thanks, Dallas. And I'll follow up with you on a subsequent question. It relates to something that our CAFII members frequently talk about in terms of the regulatory regime generally in Canada, which is that insurance is regulated provincially. We also have federal regulators like the FCAC. There is not, uniform harmonization across the country through CCIR and CISRO. There definitely are efforts by our regulators to try to be as harmonized as possible. But there are many, many examples of unique regimes or even subtle differences. And of course, our members then have to have what we call exception management, where they understand the subtle differences and what they mean and how they manage against it. It's perhaps a reality of just our federation that is a feature. And I'm wondering in privacy if that's also an issue. How well do the federal and provincial privacy regimes in our country work together, Dallas? Are they able to surmount this classical federal versus provincial authority tension that marks so much of how our federation operates? And as a practitioner in the field at Canada Life, tell us about the challenges you face in terms of trying to manage across all these jurisdictions.
Sure, that's a good question, Keith. So and I'm sure everybody's familiar with the privacy regimes in Canada, but just to go over them from the top for those who may not be. Of course, we have the Personal Information Protection and Electronic Documents Act, federal. So that's a federal legislation that governs the collection, use, and disclosure of personal information by organizations in Canada. And that applies everywhere in Canada except where there are provincial regimes in place that have been deemed to be substantially similar. So those places are British Columbia, Alberta, and Quebec. And in British Columbia and Alberta, they're called the Personal Information Protection Acts. And in Quebec, it has a very long name, Act Respecting the Protection of Personal Information in the Private Sector, I think it's called. Pardon me if I got it wrong, but those are all deemed to be substantially similar to PIPEDA. So BC and Alberta PIPA are very similar. They came out at the same time, and in a lot of places they're word for word identical, but there are some differences, and there's also differences between them and the Quebec legislation and PIPEDA, which of course applies everywhere except for BC, Alberta, and Quebec. They do differ in some details, but they're all substantially similar to PIPEDA. So compliance with one is generally speaking compliance with most of them, although they do have some differences in detail. One of those differences that's significant is the obligation of organizations to report breaches. So if personal information is disclosed to an unauthorized person, or you have a hack or something like that happens, the different legislations prescribe different actions that are to be taken. So PIPEDA says you have to report breaches both to the Office of the Privacy Commissioner and to affected individuals if there is a real risk of significant harm. And that's kind of a phraseology that comes up in a few places. It's not defined anywhere what exactly a real risk of significant harm is. Like David was saying earlier, this is a more of a principles-based approach. So, you know, each organization can determine for themselves what a ROSH constitutes, but you know, factors that you take into consideration include the sensitivity of the information, whether it was an accidental breach or somebody deliberately hacked, if you have evidence that the information is being used wrongly, that sort of thing. And that's what every organization will do to determine whether there's a ROSH and whether it needs to be reported. Alberta PIPA also requires reporting to the Alberta regulator where there's a ROSH. Quebec, you have to report to the Commission for Access to Information and the individual where there's a risk of serious injury, and you have to keep a register of those incidents. But under BC, there's no reporting requirement, but it's considered to be a best practice. The one thing that we get into that's interesting, and you mentioned it in the introduction, Keith, to this segment, is that the Office of the Privacy Commissioner Canada has expressed some feelings that might result in multiple jurisdictions asserting authority over a particular incident. So we've experienced this ourselves where, for example, you have a privacy breach with respect to an Alberta resident, but the breach happened in some other province. Now, normally we would consider that to be reportable to the Alberta Privacy Commissioner if there's a real risk of significant harm. But the Office of the Privacy Commissioner Canada has also expressed a view that since that information crossed a border, they're also seized of the matter. So if you end up reporting to two different privacy commissioners, there's a potential that you get contradictory instructions or input from those privacy commissioners about what you should be doing. And that's part of the exception management you were talking about, Keith, a minute ago, is, you know, do you report it to both? Do you report it to one and consider that that's sufficient? So there isn't, you know, perfect clarity in that, and it's possible that in those cases, the different commissioners might have different opinions of what you should be doing. So that's the kind of Canadian overview. I don't know if
Dallas, I'm hearing that it's quite a hodgepodge. In other words, I mean, there's
it is.
real
I mean, practically speaking, everything's substantially similar. So in most cases, a single standard is appropriate for companies to manage to. Quebec is always a little bit different, and you know, you always have to consider Quebec a bit separately. But PIPEDA and BC and Alberta PIPA are pretty similar. You do get into those differences when you get into the weeds a little bit. I'm not sure if you wanted me to talk about Europe and the differences between Europe and Canada yet, Keith, or should we leave that for a minute?
We will definitely get to that, Dallas, but let's leave it for now because that's something we can delve into in a little more detail. David, as a private sector lawyer at Stikeman Elliott, tell us a little bit about your own perspective around harmonization or lack of it across jurisdictions in Canada. And you're muted right now, David.
Thanks. That was I learned that lesson when my phone went off. It was probably a telemarketer calling me. That seems to be the only calls I get on my home. I still have a landline.
No, I hear you. I hear you. Same here.
Yeah. So I mean, I generally would agree with what Dallas said. It is a bit of a patchwork. I'm not sure that the federal provincial sort of challenges are are much different than they are, you know, for other types of laws, other sectors. Anywhere, almost anywhere you go in Canada, there's going to be some tension between federal and provincial jurisdictions.
Yes.
And I actually think overall things have worked out fairly well. I think businesses have been able to carry on much the same across the country, regardless of what province they're operating in and what privacy statute they've been subject to. I also think there's been, broad cooperation and consultation amongst the regulators on matters of public concern. They've issued joint policies and guidelines on things like obtaining meaningful consent, on what's acceptable when companies do video surveillance, that kind of thing. They've also issued a number of undertaken a number of joint investigations, released joint findings. So things like the big, the Cambridge Analytica case a few years ago, or Clearview AI, or more recently the Tim Hortons finding. Those were all cases where there was broad cooperation. Now, whether that will continue, I know we'll probably be, I think we'll be talking a little bit about Quebec's, the amendments to the Quebec law, which make Quebec as of now a bit of an outlier with respect to the other provinces, and that may raise some new challenges for interoperability.
So it would be fair to say, David, as a sort of summary of your comments, that the nature of our federation does lead to these slight differences, but generally the regulators have really made an effort to try to be as consistent as possible to date.
Yeah. I mean, there are minor differences, and there's additional paperwork, different forms you have to file, and different relationships with regulators you have to maintain. But I think for most companies, it has been to date, I think, fairly manageable.
Now, having said that, I know from conversations with our members that the new rules in Quebec are worrying, some of them in terms of compliance, in terms of inconsistency with other jurisdictions. Let's start with you, David. Could you tell us a little bit about what's happened in Quebec? How has it changed? And, what are some of the implications?
Sure. So Quebec is really the only regime where we've seen significant amendments, legislative amendments. There have been a few to the Alberta law. I don't think we've seen any to the BC law since it was enacted. The last material changes to PIPEDA were in 2015. But we had a whole new package of amendments for Quebec that I guess were passed in 2021. I may be losing me. And they come into force over a course of a number of years. The last one's coming into force in 2024. Some of them are already in force. This year will be the big year, though. September of this year, the bulk of the new obligations will come into play, and they it shows a new direction. I think some of the major changes, some of them are beneficial. I think so. There's now an explicit business contact exception in the Quebec law, which other laws have had for some time. So, organizations dealing in the business-to-business space, that makes life a little bit easier. There's been recognition now explicitly in the Quebec law for the notion of implied consent. Not all consent has to be, as it used to say, manifest, free, and enlightened. So that's a positive thing. There is now mandatory data breach reporting, and that is in effect as of now, which wasn't in the Quebec law, has been in the federal and Alberta laws for a number of years. So it's really just kind of bringing it up to speed with the other regimes. The test is a little different, so we do have some of those interoperability questions, that the wording is a little bit different as to what triggers a reporting obligation. Some of the other more interesting things is there's new sort of privacy by default requirements that if it's a technological product or service, the privacy settings must be the highest setting by default, which will, I think, create some challenges for those in that sector. Where personal information is used to make a decision, it has to be kept for a minimum 1 year period, which might create some issues for certain companies, including those in the insurance space, I would think. There are new transparency requirements for automated decision making, which will be work, certainly, for a number of organizations, because they'll have to be a lot more, they'll have to communicate and describe the type of systems they use now to make automated decisions. And this is it's cast really broadly. It's not just automated decisions about, will we insure you or won't we? But it could be as simple as, when you call us, do we route your call to operators on the West Coast or the East Coast because of the time difference? So there'll be a lot of challenges there. There's also new requirements to do privacy impact assessments. Anytime there's a change in your information systems, new projects that involve personal information, which puts Quebec again as a bit of an outlier for the private sector laws. We see a requirement for formal PIAs in the public sector, but not in the private sector. You also have to do a privacy impact assessment before communicating. This is the language of the Quebec law: communicating personal information to a third party, i.e. you're transferring it to a service provider, for example. And what's interesting about the Quebec law is it purports to apply to transfers of personal information, not just out of the country, which we already see in some of the in the federal and the common law provinces laws, but outside of Quebec. Saying that you have to do a privacy impact assessment, you have to get consent to do that, and as part of the assessment, when you're transferring something outside of Quebec, you have to think about the legal regime of the jurisdiction where it's going, and will it provide an adequate level of protection, and those sorts of things. There's new de-indexing and deletion rights. There's a right of portability where a consumer can request and get a dump of all the data that an organization holds about them, so they can then share that with a competing organization if they want to switch services. And as everyone is talking about, there's significant new monetary penalties, which so the regulator, the Commission d'accès à l'information, can now issue monetary penalties itself of up to $10 million or 2% of global turnover. And the criminal penalties, there are a number of offense provisions. The criminal penalties can go up to $25 million or 4%. And finally, there's the bill or the law, I guess, introduces a new private right of action, where individuals can sue organizations for damages they suffer as a result of a violation of the act.
So quite a package.
Quite a package indeed.
Dallas, I know you were referring to this new Quebec law previously earlier. I'd love to hear your thoughts on it, building on what David has just shared.
Yeah, it's intense. And I totally agree with what David was saying about it being a bit of an outlier. Like, it's quite different from what we see under PIPEDA and the PIPAs, and even the act, well, not the current act, but the former act, I guess you could call it. And it does create some challenges for organizations, including insurers, of course. Particularly wanted to zone in on the privacy impact assessment requirements. So as David was saying, you have to do these PIAs before you transfer personal information outside your organization for processing. But strictly speaking, also if you transfer it outside Quebec. And that's quite a shift. So, it may require organizations to do a bit more work. If you're collecting information in Quebec about somebody and you want to transfer it to the head office to do something else with it, you're going to have to cross your T's and dot your I's with respect to, assessing the privacy impact or potential privacy impact of performing those activities. And of course, you have to keep records of all these things that you undertake too, not only with regard to breaches, which is mandated by the law, but you're going to want to keep track of all these assessments and things that you do, just in case you get a knock on the door or a call or a complaint prompts a knock on the door or a call from the CAI. You're going to want to have evidence that you've complied with all these things to their satisfaction. And if you don't, as David said, there are these significant administrative monetary penalties that can be imposed directly by the CAI. There's, like we'll discuss about C27, there's criminal penalties as well, which are even higher. But $10 million will get your attention for sure.
Who gets put in the slammer if there's a breach? Is it legal counsel, or is it executives? I mean, who?
It's never legal counsel.
I don't think under C27 the offenses are hybrid, so they can be pursued by summary conviction or by indictment. I can't remember what the Bill 64 ones are, but there's no possibility or potential, I don't think, under C27 for actual imprisonment. It's just a monetary fine.
I see. And I'm going to ask you both, I'll start with you, Dallas, to speculate a little bit. I know that's always a bit risky, but you've both mentioned that the Quebec regime is a bit of an outlier. It's different from what we're seeing in the rest of the country. What do you think the spillover effect will be? Do you think that other jurisdictions in Canada will start to think that maybe this is the direction they should take? Do you think it could have an impact on PIPEDA privacy regime or on other provinces' approach? Dallas, what do you think?
Well, I think it already has had that effect. And we know from in other contexts, and this is said without any offense intended whatsoever, but Quebec does view themselves as a national regulator as well in many areas. So their representatives from Quebec are attending international conferences, whether it's on accounting standards or privacy or many other things. And I think they have or had an eye on getting some harmonization with GDPR to, if I could put it this way, to increase confidence in international actors that Quebec is a place that they can safely do business, because they're, in terms of privacy, because their privacy regulations and standards are right up there with GDPR, which is kind of acknowledged to be the preeminent standard in the world right now. So to that extent, I think it is having an influence on federal regulation anyway in Canada. I don't know if BC and Alberta are paying a great deal of attention to Bill 64, but C27 does have a lot of things in it that are similar. to what we're seeing in Quebec. Right to be forgotten, the right of portability, things like that appear in both pieces of legislation, and those go back to the GDPR, which is the European Union's general data protection regulation, where all of these things kind of source from. And like I was saying, that's the sort of the gold standard in the world from a privacy enthusiast perspective anyway. It enshrines privacy as a human right, which C27 doesn't, although it mentions something around it, but that was a criticism of C27 as well, that privacy isn't a human right. What we're seeing with C27 is more of a balance, like we were talking about earlier, between the interests of business and the interests of an individual in protecting their privacy. GDPR and Quebec, I think, are leaning more towards the enshrinement of privacy as a human right, and you've got to deal with that. It's not a balance of interests. These are the rules with respect to using individuals' PI, and it's not as balanced between business and individual interests as C27 and PIPEDA and PIPE are.
Interesting. And what about you, David? Do you think that Quebec's new regime could result in some jurisdictions in Canada taking a more prescriptive, a more sort of interventionist approach? You're on mute, David.
I'm trying to avoid any side noise.
Understand.
I think that certainly what's going on in Quebec, is taken into account. Politically, I think it's always difficult for one jurisdiction in Canada to be seen as not, being as consumer protective as another jurisdiction. But by and large, I think that the other provinces with privacy laws, or the federal government, aren't looking so much at Quebec as they are at international laws, and so they're more motivated, I think, by the GDPR and other global regimes like the California Consumer Protection or Consumer Privacy Act. So I think the federal law, the bill now, the C27, that would replace PIPEDA with the Consumer Privacy Protection Act, includes a lot of the same things that are in the Quebec Act, because they're also in the GDPR. So the new federal law, if it is passed, would introduce into that space some things like automated decision systems, transparency requirements, significant fines, a data portability right, expanded deletion rights, a private right of action. But helpfully, the federal bill also contains some new exceptions to consent to make businesses less consent reliant, and these reflect sort of grounds for processing similar to what's in the GDPR. So things like there's a legitimate business interests exception that would allow companies to do a lot of what businesses consider to be standard back office sort of functions. They'd be able to do that without consent. They'd be able to engage in common business activities without having to get consent.
So we've heard quite a bit about Europe's general data protection regulation from both of you, and I might ask you just to dig into that a little bit more. So my understanding is that it's the gold standard from the perspective of those that feel that there should be heightened regulations and rules around protection, but there's no doubt probably a cost in terms of doing business as a result of some of these new rules. And correct me if I'm wrong, but I believe that there's also heightened sort of litigation or monetary penalties that we read about in the newspaper from time to time, because they can be really big, whopping numbers. And so that regime sounds very different from what we've generally been used to in Canada and even North America, with the exception perhaps of California. And because I know our members are interested in understanding what might be coming down the pipeline and whether or not that might be something that we see more of, I'd really appreciate it. And I'll ask you to start us off, David, if we could hear a little bit more about what's going on in Europe and of course, in particular, how it might impact Canada.
So again, I think, Canadian privacy laws historically have measured up pretty well to European laws. Remember that, in fact, PIPEDA, was previously deemed to provide an adequate level of data protection. I mean, it was looked at by the European Commission. They said, yes, you provide an adequate level of data protection such that, personal data transfers from Europe could be done to Canada without extra controls or safeguards or agreements, that sort of thing. So there's some, both the GDPR and Canadian privacy laws are based on the same set of principles, which were originally created by the OECD, I think back in the 80s. So we've already got that, but that was against the previous European privacy standard, which was more in the form of a direction that each member state had to implement through its local legislation. So it predated the GDPR, which is actually a regulation that applies in all the member states. And the GDPR also sort of upped the ante a little bit in terms of enforcement and some of the requirements of the law. I think post GDPR, I think that in order to continue to measure up against the GDPR and maintain some adequacy status, I think Canadian privacy laws do have to reform. And particularly with respect to enforcement, I don't think Canada is going to be able to continue with the ombudsman model going forward, which is why I think we're seeing in the Quebec law and in the proposed new federal law, significant fines, very much like the ones you see under the GDPR, like tens of millions of dollars or up to a percentage of global turnover. We're seeing new order making powers. Things are really going to get much tougher. We also, I think that I've always think of the GDPR as being very much like Canadian laws, but extreme edition. And I think even though the GDPR, I think, has a huge influence, certainly in the federal jurisdiction, I think they're looking to implement what they have to, but they're still looking for a made in Canada solution. They're not holus bolus repeating all of the requirements of the GDPR. So, for example, the current federal bill has this transparency requirement for automated decision making, but it doesn't go as far as the GDPR, which gives individuals the right to opt out, to object to having a decision rendered through an automated system. Canada has decided not, thus far anyway, not to implement that kind of requirement.
Thank you, David. And Dallas, I saw you nodding your head there. You're also of the view that some changes are coming?
Oh yeah, definitely. And like David was saying, PIPEDA was approved in 2001 by the EU as being adequate data protection. So Canada is among a list of countries that are deemed to have adequate protection of personal data, so such that personal data can be transferred from the EU to Canada without any further hoops to jump through, really. And just picking up from what David was saying, the GDPR is quite intense. And it has introduced concepts that don't really exist anywhere in Canadian law. And we get a sense of these, and people on the call will know this too, when you're dealing with international entities or organizations, and they try to impose DPAs or data protection agreements on you. And these are an aspect of GDPR that GDPR requires European Union organizations to do, and they have concepts in them that are just quite foreign to Canada, like controller processor. There's different rules in GDPR as to what you have to do if you're a controller of personal data, as opposed to if you're just a processor of personal data. That doesn't exist in Canada, because right now, if you collect, use, or disclose people's personal information, the law applies to you in the same way. So that's one of the things you often see in DPAs is they'll call you a processor or a controller or something. Standard contractual clauses are another thing. We don't have to worry about those in Canada because we're adequate. We have adequate data protection as far as GDPR goes. But we are seeing, like David said, this fine levying capability by regulators, and some of the fines would just boggle your mind. Like I was looking at a few yesterday. Amazon had a 746 million euro assessment. Facebook, 265 million euros. WhatsApp, 225 million euros. And David mentioned on our preparatory call for this meeting that Microsoft and Office 365 are in a bit of a controversy with the German data regulator. I think it's called the DSK. Who found that Office 365 wasn't compliant with GDPR because it wasn't transparent enough about where people's personal data went and what it was used for by Microsoft when they're using these cloud applications and things. So the activism of the regulators in Europe with respect to GDPR has really caused some issues. And when you combine it with their ability to levy these giant fines, it's creating challenges for people doing business there.
That's really interesting. I just want to pause for a second. We have 15 minutes left in this webinar. The time has just sped through. You've both been so knowledgeable and insightful. So I really feel the time has whipped by. I just want to sort of deal with a couple of other topics quickly in the remaining time, but I do want to remind those attendees on the call that we welcome your questions. There's a Zoom icon on, or a Q&A icon, excuse me, on Zoom. And if you just click on that, you can pose a question. It will come to me and I'll be happy to pose it on your behalf. Dallas, David, I'd like to talk a little bit about some of these trends that you've discussed in relation to insurance. So insurance, and we discussed this in the call we had in preparation for this webinar, insurance is data hungry, and it's also sort of data dependent. I mean, if you think of the process of establishing premiums or of risk appetites or of risk classes, it's all based on statistical and actuarial analysis, and so data is central to that. Now, I know that there's a distinction between my private data and then aggregated data, but it sounds like that line is being blurred a little bit. And with the emphasis on new technologies, on artificial intelligence as ways to drive greater insights into insurance products, into insurance risks, I'm wanting to ask you, what are some of the areas in which companies will need to be careful, and where some of these new regulations and rules and requirements could have constraints or challenges for companies that want to use data to drive better results for their consumers, but having to be mindful of some of the limitations that may exist based on these rules. David, let's start with you on that one.
Sure. Well, I think that any business, including insurance, that is sort of data dependent. One of the big shifts in the landscape is the attention being paid to de-identified data in new privacy amendments and proposed privacy amendments. So previously, it was kind of a binary question about, whether you're dealing with personal information or non-personal information. And so if something was personal information, if it, was associated with an identifiable individual, and non-personal information means it wasn't. And the test was really, is there a serious possibility that, this could be associated with an identifiable individual? And if it wasn't a serious possibility, the law didn't apply. The laws now are sort of looking at that and saying, well, we've got sort of maybe three categories. We've got personal information, which can be identified. We've got anonymized information, which absolutely cannot be identified and isn't subject to the law. And then we've got this vague category in the middle that we're going to call de-identified information. And so this is information where there may or may not, there may be a possibility that it could be related to re-identified, yes. And the law really treats that de-identified information now, and it's a very vague definition. So it could include sort of aggregate level information, statistics even. Basically, if the data was ever personal information, if it was derived from personal information, it is essentially treated for many purposes as if it was personal information. So the laws would, include provisions restricting the use of de-identified data, certainly very harsh restrictions on the disclosure of that information to other parties. There is in the federal law, there's this sort of concept about permitted disclosure of de-identified data for socially beneficial purposes. It's not clear what socially beneficial purposes means, and it's only permitted currently to a fairly small list of potential recipients. So that's a big thing, I think, of concern for any data-driven business. The other things, as I mentioned, there's sort of transparency obligations about automated decision-making. And I think we're also likely staring down some more prescriptive regulation on artificial intelligence. So to the extent using an automated system that has an automated intelligence function, something that it does on its own, independent of programming. I think that's also going to be a great concern.
Thanks, David. Dallas, your thoughts on this?
Yeah, so we haven't really gone into great depth on C27. It's a bill that's in second reading in Parliament in the House of Commons right now. But since we're talking about it, maybe I'll just give a very high capsule summary of it. It will replace PIPEDA, as David mentioned earlier. It's got three elements. It's got the Consumer Privacy Protection Act, which is kind of the, so to speak, the direct replacement for PIPEDA. Then it's got two other things as part of it too. The Personal Information and Data Tribunal Act and the Artificial Intelligence and Data Act. So all of those things are going to impact the way we do business. As we were discussing earlier, there are things in there that are lifted from GDPR that are going to have impact on how we do things. This right to be forgotten, de-identification of personal information. There's a right of portability in there that comes from GDPR as well. And it's fairly unclear as to how that's going to be managed by industry in Canada. One of the really interesting things to me about C27 is this establishment of the Personal Information and Data Tribunal. And I think it's positive, generally speaking, for industry that it's there. Because it gives a little bit of a buffer between what the OPC can do to you directly. And that is if the Privacy Commissioner was desirous of levying a giant fine on an organization for doing something, this gives a little bit of a second look because they have to have that approved by the tribunal. The tribunal requires or gives organizations and the OPC a right to be heard. So you get a chance to make a representation to the tribunal before a giant fine is levied on you. And there's also in the context of these fines, a due diligence defense as well. So some privacy enthusiasts and critics have been critical of that element, but I think it's going to ameliorate the possibility that we're going to have these giant fines in Canada that we've seen in Europe. But at the same time, it does give a bit of a goad to organizations to behave appropriately, and it addresses some of these concerns that the privacy commissioners have expressed, that they don't have a right to make orders or to levy fines directly. So it's kind of is positive for the enforcement end, but the way they've done it is, I think, positive for industry as well, because you have that second chance to respond. The AI stuff is interesting too, because obviously the insurance industry uses automated decision-making processes, and there's the potential to use automated decision processes from everything from the application and underwriting and to claims at the other end. So if C21 or C27 rather comes into force, these processes will need to be reviewed in the context of the AI portion of the legislation. They'll have to be reviewed for compliance, and basically that involves transparency to people as to when these automated processes are used. And of course, when we're developing new automated decision processes, the legislation will have to be referred to make sure those processes are compliant. Now, some of the transparency involves publishing what the legislation calls plain language descriptions of the system, and for certain systems to establish measures to mitigate the risks of harm or biased output. So that's going to be, or may be, challenging for organizations to do in the context of automated decision making, because those decisions are often just binary, and you know, the risks of harm or biased output may be difficult to determine. So that's going to be a bit of a challenge. It's interesting as well that this goes together with privacy, because although the decisions are being made based on information, they're based on information of two people, the applicant and then all the people whose information was aggregated to make the model that the automated decision-making process uses. So, you know, like David was talking about de-identified information, some care is going to have to be taken that the information that's being used to create the model is dealt with appropriately, whether it's truly not personal information anymore, or whether it's de-identified information that could be re-identified. That's going to make a difference in how you build your model.
All right, thank you, Dallas. We only have a few minutes left. We do have a question from the audience, a quite good question. I'll just read it and ask you for your comments. Appreciate your thoughts on the following. Under PIPEDA, as was noted, Canadian jurisdictions that enact privacy legislation are required to ensure their local law is substantially similar to PIPEDA. However, it would appear Quebec's new stricter privacy legislation no longer is substantially similar to PIPEDA. Does this mean the feds are now in the difficult position of almost being forced to play catch up? How concerning is this development? David, why don't you start us off on this?
That's an interesting question. And I guess I've always, it's not explicit, I don't think, but the whole notion of substantially similar, I think, was intended to ensure that provincial laws met a kind of minimum standard. I don't think it was intended to prevent them from exceeding that standard. Although, again, that's not explicit in the law. But I expect that the federal government is pretty unlikely to reject Quebec's, you know, more restrictive privacy law, saying, well, you're no longer substantially similar because you went further than we did. I just politically, I can't see that happening.
Yeah, that would be a bun fight of epic proportions for sure. But I totally agree with what you're saying, David, too. I think it was meant to say that the provincial legislation, in order to be substantially similar, has to meet, you know, a minimum standard. The follow-on question from that, though, is if C27 is enacted, would BC and Alberta PIPA be considered substantially similar? Because they have, there's a lot of deficiencies in those pieces of legislation as compared to what C27 would be. So, you know, I don't know and can't predict what would happen with that, but that would be an interesting question.
Yeah, I would think it would be quite likely that they would have to be revised. But I mean, there's uncertainty on the point, but I'll throw I'll throw my money into that pot, that they would have to be revised.
Yeah,
so some interesting prospects going forward. Just to wrap up, I'd like to ask you, David, and then you, Dallas, just for your final thoughts and words of wisdom in terms of those of us who watch privacy developments. What are some of the things you think we really need to pay attention to? David?
Well, I think it goes back to this whole notion about big data, real concerns about big data, about sourcing data that goes into sort of number crunching and modeling algorithms, whether there's consent for the sourcing, whether there are new harms arising because of the aggregation of data from really broadly dispersed sources. And the focus is on sort of bias. Is there any overt bias, or particularly when you're dealing with an AI system, is there kind of bias sneaking into it? And are there material harms to individuals? That's the main focus. And a lot of that thus far has been directed at social networks, search engines, who are a lot more sort of front and center. But I think it's quite possible that that sort of attention increasingly will get turned to individual companies and how they're handling data. And I think today's ruling with respect to the Home Depot findings is maybe one example of that, looking at an organization using data for its own purposes. I think we also need to keep an eye out for, there's a real push in some quarters for Canada to take a more human rights-based approach to privacy laws, such that we've seen in Europe, and that could be a real cause for concern, because it really means that business is always on the back foot. Always has to justify any use of personal information and why that should be acceptable.
Thank you, David. Final word to you, Dallas.
Well, I guess I would say there's always an expectation that the GDPR would make its way to Canada eventually in some kind of form. And certainly, as David set out, the Quebec law moves us a bit farther in that direction than does the CPPA and the other legislation under C27 that will be established or may be established. Some privacy advocates have definitely been less than enthusiastic about C27 because they think it doesn't go far enough. But I think it strikes a pretty reasonable balance in most aspects between the interests of business and the interests of people. Will the CPPA, if it's enacted, affect business processes? Yes, it will. Consent is still emphasized as the prime directive in conducting business using people's personal information. Bill 64, the law in Quebec, also makes the consent requirement a lot more granular. There are some positive aspects to C27 as well, as David pointed out, like the business exceptions that are built in for uses of information that you don't need consent for. But organizations will have to revisit and perhaps redraft these consents to meet the new rules, including rules related to plain language and understandability of the consents. And we talked about the net new aspect of C27, which is this Artificial Intelligence and Data Act. And as David mentioned, and I completely agree with him, that's going to be something that will require work to comply with if it comes into force, and is something definitely to watch.
All right. Well, thank you both. You've both been so insightful, so knowledgeable, and I know I speak on behalf of the CAFII membership and our other partners and stakeholders when I say that we really appreciate your giving us an hour of your valuable time. This webinar has been recorded and will shortly be posted on the CAFII website, CAFII.com, and our next webinar will be on the 30th of March on mental health issues in the workplace. More information will be coming to you soon about that. On behalf of CAFII and its board of directors, thank you all so much for participating, and I wish all of you a great rest of your day. Thank you and good afternoon. Bye-bye.
Thanks.